In the name of God, the compassionate, the merciful. Welcome, friends, to what I believe is the 72nd episode of Crime and Punishment, a legal podcast, not a political one. We here at Crime and Punishment have no political views. We support whoever is in power at the moment. We would never rock the boat. We are here only for legal commentary. This is the podcast of the Invictus Law Firm, PA, a criminal defense law firm in Orlando, Florida, the website for which is augustusinvictus.com, and that is me, yours truly, the host of this program, here to talk at you today about the basics of criminal law. For those of you long listeners out there who have been with us for the past 2 years, we've been doing this program, 2 years plus. It's amazing that in only 2 years we have, should I say in 2 years, we have only 72 episodes, which should mean we've done it like every other week, but in reality it means that I did it weekly and then I take months off at a time and then do it weekly like we're doing right now, so it evens out. Anyway, we used to, when this program began, talk about things like legal concepts, and we've read through Carl Schmitt. We've talked about, First Amendment law and constitutional law and a whole bunch of other stuff. So they're telling me on Twitter they're dealing with cops in France, secession. I don't know what's going on there. We're talking about American law today. And, hey, good evening from the East, Brian. I have been meaning to call you for weeks, so please holler at me before this program is over, man. Text me and we'll talk. What's up, John Gordon Meade? Long time no see. So today we're going to talk about the basics of criminal law. It's in the Criminal Justice, Chapter 15 of the Family Legal Guide by the American Bar Association, believe it or not. Because I'm all about showing everyone how I have no hard feelings. American Bar Association is, of course, one of my favorite punching bags, because now they're just basically a milquetoast SPLC. It's this leftist think tank that, pushes their agenda down everybody's throats in the legal profession. But this is a work of art, this Family Legal Guide. It has everything your family needs to know about the law on real estate, consumer protection, healthcare, retirement, home ownership, wills and estates, computers, and much more. This is the third edition. I got it from the library one day. But Chapter 15 is part of that and much more. It's on the criminal justice system, so-called anyway. Our system of justice was designed carefully to prevent people from being unfairly convicted by guaranteeing many legal rights to anyone charged with a crime. You know what? We'll just keep going without commentary. For example, you have a right to have a lawyer present during police questioning. You have the right to remain silent to avoid incriminating yourself, which means that you do not have to answer any questions asked by police and do not have to give evidence at trial. Just being aware of these rights will help you if you ever become involved with the criminal justice system. This chapter discusses those rights, provides you with a basic understanding of the steps in the criminal justice system, and suggests where you can look for more help. It also provides information on the role of other people involved in the criminal justice system: victims, alleged victims, that is, witnesses, and the jury. One thing I've pointed out multiple times, my friend told me that this show should be geared toward other lawyers, to teach them how to practice law ethically, and just how to practice law, right? So one of those things is the use of the term victims. There are no victims, until somebody's convicted, right? In a trial proceeding, if you are a defense attorney and you use the word victim, you should be locked up. If you are a defense attorney, you will always, or a judge, it's even worse if a judge calls the person a victim, but whether you're a defense attorney or a judge, it is always the alleged victim. No one's proved anything yet. Your client is not convicted. Don't you dare call the complainant a victim. They're an alleged victim until someone proves that this crime happened. And if you're a judge using the word victim, you've automatically prejudiced everyone in the courtroom against the defendant. So it is always an alleged victim. Good afternoon, Ulfric. Long time no see. Thanks for joining us, man. It is important to be informed about the criminal law in your jurisdiction. Most crimes are punishable under state rather than federal laws. For now, right? This was written in 2004. Some, like drugs and weapons offenses, may be punishable under both state and federal laws. Although all states must comply with certain federal constitutional minimums, there are considerable variations from one state to another. For example, some state constitutions provide a higher degree of personal and procedural rights to the criminally accused than others. Therefore, the information in this chapter generally will be true in most states, but may not be true in all. That's a good legal disclaimer. I should also add that this program is for entertainment purposes only, and that only your lawyer in your state, licensed to practice in your state, should be giving you legal advice. This program is not to be construed as legal advice for your matter or anyone else's matter. The basics of criminal law. Kevin was charged with assault after a bar brawl. This is fictional. Any resemblance to real-life characters is an accident. Kevin was charged with assault after a bar brawl. He was arrested and taken to the police station where he answered police questions and informed them that someone else started the fight by throwing a punch at him. He told his lawyer the same story. At trial, Kevin agreed to give evidence, saying he had nothing to hide. The first question the prosecutor asked him was whether he had any other convictions. To his lawyer's surprise, Kevin said he had 2 other convictions for assault. This section provides an introduction to issues related to the criminal justice system. So they're giving you this hypothetical situation. Several things in there for all of you good citizens out there. First of all, never lie to your lawyer. Not that Kevin lied to his lawyer. He just didn't disclose, but that's a different story. Never lie to your lawyer. You might think that, well, if I get my lawyer on my side, he'll lie and tell my side in court. Bad idea. Bad idea. You have no idea what the prosecutor has or what some other witness is going to say. And if you lie to your lawyer and your lawyer gets blindsided in court, you're out, buddy. Lawyer's already putting his neck on the line for you. He finds out you're lying to him and he gets made to look like a fool because he put forward this thing and didn't know something. Boy, does he have egg on his face. And how hard do you think he's going to fight for you after that? Right? And then there's the not disclosing things, which can be in tandem with lying. So they're talking about Kevin here had 2 other convictions for assault. That's important. You might not think that a conviction for, I don't know, Grand Theft Auto or, some other tax evasion, whatever. You might not think that's relevant. Like, why would I tell my lawyer that? This is a bar fight, right? But Kevin here has 2 other convictions for assault. That's something important that you should probably have told your lawyer, right? Especially their felony convictions, because that's going to play into what the prosecutor is going to offer. If the prosecutor knows that and your defense lawyer doesn't, that's a serious problem. I once had a client lie to me. I specifically asked him, do you have any prior convictions? And he said no. So the day of his plea, the prosecutor came to me and said, Mr. So-and-so actually does have this conviction, felony conviction in County X. And I went to him and said, look, man, the prosecutor says this. I went and looked it up, and you do have this conviction. And he said, oh, well, that was in a different county. That doesn't matter. You still have to disclose that. So don't lie to your lawyer. Tell them everything you think is relevant. Felony convictions are always relevant. Just tell them any convictions, really. So those are a couple things just right off the bat with this hypothetical situation here. Question: how does civil and criminal law how does civil and criminal law differ? Answer: civil matters are private matters, which involve the plaintiff suing the defendant for a money award, often in combination with other orders of the court, like an injunction to make a party stop a course of action. A crime is considered a wrong against the public. Although a criminal defendant may have injured only one victim directly, any violation of the criminal laws harms society. Criminal cases are always initiated by the government, which has a monopoly on bringing charges. This is the American legal system. Should I say the Anglo-American legal system? This is different than the ancient Roman system, where one citizen could take another citizen to court for, say, murder. Can't do that here. Only the government can do that. That's why in the case heading, you would see State of Florida plaintiff versus whatever the defendant's name is, right? Because, Sally cannot bring an action against Johnny for murder, right? Sally can't say, you murdered my daughter, I'm taking you to court and putting you in prison for that. No. The government has a monopoly on that. And this is extremely significant. This is how, eventually, our state just ran away into a police state. The government creates a monopoly on being able to charge you with crimes against the public, which is what the ABA is saying here. This is not a crime against Sally or Sally's daughter. This is a crime against everybody. This is a crime against the state of Florida. You murdered a Florida citizen, or you murdered someone in Florida. This is an offense against the state. So only the state can bring this criminal charge against you. They've monopolized the idea, the very notion of a criminal charge. They've also monopolized violence. And we've seen this slippery slope. We've seen this slide over centuries from, we used to have a maxim, a legal maxim, volenti non fit injuria. The willing cannot suffer injury. So if you engaged in mutual combat in, say, a parking lot or a bar fight, you can't bring the other guy to court because the willing suffer no injury. You consented to this. You will suffer your own consequences. Keep it out of my courtroom. Now, it doesn't matter. It doesn't matter if the other guy doesn't want to go forward with it. You fought in a bar. You fought in a parking lot. You committed a battery. And you've now committed a crime not against some dude in a parking lot or some dude at the bar who looked at you wrong. You've committed a crime against the state of Florida. So now the state has monopolized violence. It doesn't matter if guy X in the parking lot consented to this mutual combat. You have offended the state of Florida, and you will be charged with a crime. Now, that's the legal theory. In reality, of course, you can talk to a prosecutor, a reasonable prosecutor, an ethical and reasonable prosecutor, and say, look, this guy doesn't want to press charges. He filed a declination of prosecution affidavit. He's not coming to trial. He doesn't want to go forward with this. Like, what are we doing here? This is a waste of time. It's a waste of the court's resources. Like, come on. And it will be dropped. I mean, it can be dropped. Not, you can't predict what people are going to do, but in practice, that whole theory of state monopoly of violence, it can be hacked away at, but that is the theory under which we operate in this criminal justice system. The state has the monopoly, the state files the charges, and the state can go forward with charges even if the alleged victim wants nothing to do with it. So, the defendant in criminal cases is usually a person and very rarely a corporation, although obviously that does happen as you see in the news. While victims of crime may be consulted, they have no power to make the prosecutor bring charges or to prevent the prosecutor from dropping charges. A convicted defendant may be ordered to pay a fine. Well, let's go back to that. Victims may be consulted. Alleged victims may be consulted. They have no power to make the prosecutor bring charges or to prevent the prosecutor from dropping charges. Let's get into that. Generally speaking, yes, that would be accurate. However, recently, Florida passed Marsy's Law. A lot of states, I think, are on this feminist, Marxist tidal wave of let's just let the victims #BelieveWomen run everything, right? So let's forget about this 1,000-year tradition that we've got in the law. Let's forget about the rules of evidence, the presumption of innocence, all the things that we've held sacred all our lives and for centuries and even millennia. Forget all that. Hashtag believe women. Every victim has rights. Now you have the right to an attorney. You can, not legally, but politically and realistically, you absolutely can force prosecutors to press charges. And we've seen that over and over, not just in hashtag believe women cases, but look at Trayvon Martin. Don't ban me from YouTube. This is legal commentary, not political. Talking about the prosecution of George Zimmerman. They let the man go. They let the man go. It was obviously self-defense. And then people start rioting. And people put political pressure on the prosecutor. Obviously, Trayvon Martin is the alleged victim in that case. And of course, the community has to speak for this deceased person. Put pressure on the state attorney's office. State attorney's office, sure enough, prosecuted George Zimmerman for what was clearly a self-defense case. So that's an extreme example where a victim can force the state to press charges, but legally speaking, the book is right. Because only the state has the power to do that. And even while laws like Marsy's Law or other victim rights laws will grant a lot of power to victims, alleged victims, the fact is they can't force charges to be brought, and they cannot stop a prosecutor from dropping charges. A good prosecutor will contact this alleged victim and say, look, I feel for you. I know you've been through a lot. It's a tough time for you and your family, so on and so forth. However, I've looked through the file. I've talked to the witnesses. I've looked at everything, and I don't think there is cause here to go forward with a trial. I don't think that a reasonable jury would find him guilty. Or her, but let's be real here. So I'm going to file a nolle prosequi, a nolle pros, and I'm going to dismiss this case. That happens. It does. And the victim, alleged victim, cannot force them to keep going with the case. However, a lot of times what happens is they'll just keep going. And in some cases, they'll keep going even when the alleged victim says, I want nothing to do with this case. Even when the alleged victim says, I lied about everything. In those cases, extreme cases, some might say, the prosecutor will outright extort those alleged victims and say, if you change your story, if you don't show up at trial, if you do X, Y, and Z things, or X, Y, or Z things that are going to jeopardize my case that I have on my desk that I've been working on for months because of you, I will charge you with a crime. So this person, the defendant, they're going to be let go, and then I'll come after you. So you are not going to change your story. You will show up to the trial. If you don't, I will put out a warrant for you to be dragged into the courtroom. You will testify. And you will testify in the way that you testified to me earlier and to the cops. Or you're going to be the defendant. So that happens sometimes. There's a complicated interplay here. It's, of course, prosecutor to prosecutor. It's, of course, case by case. But generally speaking, the ABA is giving you the rules here. A convicted defendant may be ordered to pay a fine, given probation, given community service, or sentenced to jail or prison, or even death. That's a very simplified way of looking at it. Question. Are there different standards for determining liability in a civil suit and guilt in a criminal case? Answer. Yes. The Bill of Rights, the first 10 amendments to the U.S. Constitution, together with state constitutional provisions, treats a criminal conviction and the possibility of a prison term or death sentence as more serious than a finding of civil liability. Accordingly, it is more difficult to convict someone of a crime than it is to obtain a civil judgment against the defendant. In a civil suit, The question that a trial judge or jury will ask when making a decision is whether a plaintiff has proven that it was more likely than not that the defendant was legally responsible for the plaintiff's injury or loss. This preponderance of the evidence standard means that if the evidence favors the plaintiff by even the slightest bit, the plaintiff is entitled to a verdict in his or her favor. In a criminal case, on the other hand, the standard is much higher. The prosecution must prove the defendant's guilt beyond a reasonable doubt. Even if it is more likely than not that a criminal defendant is guilty of the crime charged, the proper verdict is not guilty if there remains a reasonable doubt about his or her guilt. Where to begin with that one? Let's begin with voir dire. So there are certain stages in the trial once it's actually trial time, and there's a bunch of lead up, right? There's the investigation, if there is any investigation. Often they, shoot first, ask questions later, but let's say there's an investigation. There's an arrest. There's the discovery phase. You go to pre-trial. You get the case continued. You do whatever leading up to the trial. And finally, you get to trial. That first day that you're in trial, you are choosing a jury. This is the voir dire process. You can ask general questions. You can, I won't say target, but you can call on specific jurors and you can ask them about things in their questionnaire, or at least this is in Florida. In South Carolina, what I saw, completely different scenario for voir dire. But in my experience, you can question jurors, you can isolate them, having the entire jury leave, and you can bring one juror in. You can ask them questions so that they won't taint the entire jury pool when you're asking them something, like something offensive, for instance, like, what are your opinions on George Floyd? Like if you asked, have any of you been to a George Floyd protest, and one person raised their hands, you wouldn't start drilling them about that in front of everybody else. You would let the entire jury leave and bring that guy back in and say, all right, what were you doing at that protest? What are your views on this? And this would be relevant if you were defending, say, Derek Chauvin, right? And we've talked about that on a previous episode. So one of those things that you discover in conducting voir dire as a criminal defense attorney is that no one gives a hoot about the beyond a reasonable doubt standard. No one cares in America. Now, civic education is dead. You bring someone in modern America, you bring them into a courtroom, and they're about to sit on a jury to determine whether somebody should hang or not. The majority of people, they're not thinking, well, the prosecutor has to prove his case, or I'm voting not guilty and I'm going home to my wife. The average person, rather, is thinking, well, he's sitting there with a criminal defense attorney. The cops thought he did something. The prosecutor clearly thought he did something, or they wouldn't be here. He's got to have done something if he's sitting in that chair and we're all called here. Something ain't right. That's what the average American thinks. No one thinks anymore, well, the state has the burden of proof. This person sitting at this table is innocent until somebody proves otherwise to me. No one thinks that anymore, if they ever did. Maybe they thought that before we were born, but in my adult experience, absolutely not the case any longer. The United States Constitution guarantees criminal defendants many other rights, including the right to a jury trial when there is the possibility of a conviction resulting in a prison term of 6 months or more, the right to have a lawyer appointed if the defendant cannot afford to hire one where there is a possibility of the loss of liberty, the right to confront one's accusers, and the right to a swift and public trial. State constitutions may guarantee other rights, including rights to a jury trial in lesser offenses. So that last sentence is pretty essential. State constitutions may guarantee other rights. What's not said, because maybe they think it's so obvious, is that state constitutions can't take away rights, right? So the federal constitution guarantees you freedom of speech, freedom from, quartering troops, That's an obscure joke. Freedom from, search and seizure. Like, you have all these basic rights. State constitutions can't chip away at those or say, well, here in Alabama, we ain't believe in no freedom of religion for no Hindus. You can't do that, right? But you can give more protections. So the right against search and seizure, for instance, that has famously been just whittled away for decades by the Supreme Court. Why do we even talk about the Fourth Amendment anymore? You don't have any right to privacy. You don't have any right to prevent the government from doing whatever they want to search your things or wiretap you or whatever they're going to do. But, Idaho could say, well, we don't like the way Supreme Court jurisprudence has gone. We think that the Fourth Amendment has been eroded over the decades. And here in Idaho, the police are not going to have any right to do anything because here in Idaho, our Idaho citizens are protected under the Idaho Constitution against unreasonable searches and seizures, against any search without a warrant or exigent circumstances, which will be described in, A through G. So they can add protections to those basic rights, but they can't take away more rights, right? But going back to what was said right before that, these are other rights that are being whittled away. One of them being, where there's a possibility of loss of liberty, the right to confront one's accusers, the right to a swift and public trial. You do have the right to a speedy trial, at least here in Florida. I don't know about everywhere else, but here and in South Carolina, again, totally different world. It was explained to me, you have the right to a speedy trial, but it's a right without any enforcement mechanism. There's no way to actually secure that right or exercise that right. So it's kind of like a right that just exists on paper. Here in Florida, you have to bring someone to trial within a certain period of time or the case is dismissed. There is a very real penalty for the state just hanging some criminal charge over your head, just to screw with you or whatever they're doing with it. You have actual rights here, but even those can be chipped away. The biggest one here, the right to confront one's accusers, that is one that, like the Fourth Amendment, has been chipped away over and over and over again over the years, to the point where it's becoming, all but a legal history. Where to even begin with that? The protection of confidential informants, the protection of alleged victims, these so-called protections, officer safety, undercover officers, like all these cloak and dagger KGB style prosecutions, right? Where everybody's got to be protected, everybody needs safety, and so on and so forth. That's the entire reason we have public trials, right? Is so that you have to publicly accuse a man of a crime, and you have to come in there and submit yourself to cross-examination. That's the entire point of our legal system. But even that, well, this person is, alleged to have committed crimes X, Y, and Z. And there was probable cause, Judge. You know it because you signed the warrant. Or, Judge so-and-so in the other courtroom signed the warrant. And there's probable cause here. And this is a dangerous man. And we have to protect these people's identities. Got to black out pages and pages and pages of the discovery that we're sending. So this guy can't even see what we're accusing him of exactly. All this just, I hate to use the word statist, but what is the word where you have a government so out of control that they hide evidence against the man. He can't even see what he's accused of. Happens all the time. And always on the grounds of, well, we got to protect people. We can't have victims scared to come to court. Can't have witnesses terrified of what's going to happen. We can't have people bullied on the stand. Yes, you can. That's the whole point of cross-examination, is to prove someone is a liar. And if you don't stand by what you say, don't come to the courtroom. That's the whole point of cross-examination. And we've whittled it away, and here we are. Question: how does the criminal justice system work? Answer: it is useful to think of the criminal justice system as being made up of three components. 1. Law enforcement, the police. 2. Courts and adjudication. After arrest, the defendant is charged and brought into the court system to have his or her case heard. 3. Corrections. If a defendant is convicted, he or she may go into the correction system, jail or prison, or probation. Question: what distinguishes a misdemeanor from a felony? Our viewership has dropped precipitously since I started going on a rant about protecting people from cross-examination. I guess we've outed all the feds that were in the chat there. Question: what distinguishes a misdemeanor from a felony? Answer: each state has a body of criminal law that categorizes certain offenses as felonies and others as misdemeanors. The federal government and most states classify a felony as a crime that carries a minimum sentence of more than 1 year. A misdemeanor is an offense punishable by a sentence of 1 year or less. Some states draw the line based on the place of possible confinement. If incarceration is in the state prison, the offense is a felony. If the offense is punishable by a term in a county jail or a state facility other than a prison or a reformatory, it is a misdemeanor. So, here, for instance, if you are convicted of a misdemeanor, you cannot serve more than a year, and you will serve that time in the county jail. Or even if you get probation, you can't get probation for more than a year if you're convicted of a misdemeanor. You'll get 6 months, or you'll get a year with possibility of early termination. If you have a felony, you're looking at least a year and a day. So sometimes the minimal prison sentence will be a year and a day that you're taking a plea for. Or if you're on probation, you're going to get a year and a day. And again, you can terminate early, or you can move the court to terminate early anyway. But that's the basic distinction. And that is the distinction here in Florida. Like the ABA says, most states, that would include Florida. It used to be, for those of you who have missed previous episodes of this program, it used to be that a felony was something you were hanged for. Horse thievery being my favorite example, because if you stole a man's horse, you stole his livelihood. Robbery, rape, murder, these were felonies. Burglary, like actual crimes, right? Now, everything is a felony. Now you have a Xanax in your pocket, it's a felony. So, the definition of what a felony is dramatically changed. So that now, like the ABA is saying, it's a year or more in prison. And if it's a misdemeanor, it's a year or less in the county jail. Or probation, whichever. Felonies are more serious crimes than misdemeanors, continues the ABA. Robbery, kidnapping, sexual assault, and murder are examples of felonies. Again, things you would be literally hanged for 100 years ago. Public drunkenness, resisting arrest, and simple battery are misdemeanors. Depending on the degree of the offense, however, the same offense might be either a misdemeanor or a felony. Petty larceny, stealing an item worth less than the dollar amount specified in the relevant state legislation, is a misdemeanor. Over that amount, the offense is grand theft, a felony. Similarly, the first offense of driving under the influence of drugs or alcohol may be a misdemeanor. After a certain number of convictions for the same offense, the state may prosecute the next violation as a felony. Same is true of driving on a suspended license, so watch out for that. Question: how do juvenile proceedings differ from adult criminal proceedings? No offense to the teenagers in the audience, but we're going to skip that section. I don't really do juvenile law, to be honest. Then they have a section here on the characteristics of some serious crimes. Crimes against the person, crimes against property. All right, here's an important section. The requirements of a crime. We got about 20 minutes left. Most crime requires both a criminal act, the actus reus, and a criminal intent, the mens rea. Even if you committed a criminal act, injuring someone, for example, you might not have had the required mental state or wrongful purpose for it to be a crime. In other words, your state of mind has to intend the crime. That's the mens rea. Both criminal act and criminal intent must be proved beyond a reasonable doubt if a person is to be convicted of a crime. If the facts in your case show that you did not have a criminal intent, then all the elements of the case have not been proved, and you may not be convicted of a crime. You can be convicted. Here's what I was going to get into. They beat me to it. You can be convicted even if you did not intend to commit a crime in some circumstances. A person who kills another unintentionally commits a crime if his or her actions were reckless or sufficiently negligent. For example, if an accident occurs while you are driving 100 miles an hour on a city street and a pedestrian is killed, you've committed a crime even though there was no conscious intention to injure that person or anyone else. There are also, the ABA does not list this anywhere in here. Yep, I don't see it in here. There are also strict liability crimes, where state doesn't have to prove anything. You did it. Doesn't matter what your intent was. You're going to prison. I think the most infamous, the most notorious example of that is the statutory rape laws. It doesn't matter if you thought she was 18. She was 17. Strict liability. We don't care what your state of mind was. It doesn't matter if she showed you a fake ID saying she was 21. She was 17. You're going to prison. I do remember hearing about one case where this girl was deliberately targeting older men using a fake ID, had this whole con game, right? And then would set them up to be imprisoned, like would get this whole game where she was setting men up to take criminal charges. And finally the judge was like, no, we made these laws to protect young women and you can't use them as a weapon. I don't know which state that was. That was years ago, but some judges could use a little more common sense in that regard. But that's a strict liability crime where the state doesn't have to prove your mens rea. They only have to prove that it happened, right? Let's see. Characteristics of committing crime. The police and your rights. The immigration consequences of conviction, we probably don't need to go into. Basically, if you're convicted of a crime, you can be deported. And if you take a plea, the judge will always go into that with you. Do you understand that if you're an immigrant, you can be deported? They ask you that even if you are not. It doesn't matter. All right, so the police and your rights. Let's go to that section. Because I did say that we're going to talk about the basics of criminal law and how to deal with the police. So, this is the second section. It's a lot lengthier. We're not going to be able to get through all of this in the next 20 minutes. But we'll do our best. Let's skip over this Terry v. Ohio thing. They have a hypothetical situation like they did with Kevin in the last section. We're going to skip over that and go straight to the questions. Question: how do the police investigate crimes? I can't wait to find out what the ABA has to say. Answer: when the police receive a report of a crime, such as a home burglary in progress, they send investigating officers to the scene as soon as they can. If the officers arrest a suspect, they will transport that person to the police station or the jail for booking. The officer will write an arrest report detailing when and why the officer went to the scene, along with any observations and why the officer arrested the suspect. The officer also will fill out a property report detailing what items, for example drugs or cash, the police found on the suspect during booking. Actually, I have a case right now where they listed a Slim Jim wrapper. Like, they'll list anything, anywhere. They'll list it in the property records. The officer also will list any items of evidence found at the scene, such as tools the suspect might have used to gain access to the home. If the crime is complex or serious, the police then assign an investigating officer, usually a detective, to the case. That officer will make a return visit to the crime scene, look for more evidence, and interview any other witnesses. Yeah. I mean, if they're doing their job, they will. If the police have not arrested anyone, the detective will analyze the evidence and try to narrow down the list of suspects. The detective will question suspects and sometimes will obtain a confession. All right, well, that's, I guess, a pretty general rundown. Question: how long may police hold suspects before charges must be filed? Answer: if the police have probable cause to believe a person has committed a crime, but the prosecutor has not yet brought formal charges, the police may detain the suspect in custody for a short period of time, generally 24 to 48 hours. Probable cause is defined as fact sufficient to support a reasonable belief that criminal activity is probably taking place, or knowledge of circumstances indicating a fair probability that evidence of crime will be found. It requires more than a mere hunch, but less than proof beyond a reasonable doubt. After this short period of detention, the police must release the person, or bring formal charges and take the suspect before a judge. If released, the person may be rearrested at a later date if the police obtain sufficient evidence. About 24 to 48 hours. There's such a problem here. I don't know. Maybe it's just Florida. From what this is saying, 24 to 48 hours. They hold people here routinely for 30 days at a time without filing any charges, such that we have to file 30-day motions to get someone out of jail if they're being held without bond for some reason. Right? But there has to be a period of time where the state has to either, defecate or get off the pot. They have to decide whether they're going to charge someone or not, especially if they're keeping them locked up. Now, there's also the fact that if you've arrested someone and they're not in jail, they're at large, you can't have a criminal case just hanging over their head for years. You've got, 6 months to file those charges, or defense can file a motion to have the whole case dismissed. Like, you can't just hold this over somebody's head for years, right? Well, we have a constitution. Question: do the police have the right to tap my telephone? Answer: yes, if they can show the court that they have probable cause to believe that intercepting your telephone conversations is necessary to help solve certain crimes, such as treason, terrorism, drug trafficking, wire fraud, and money laundering. The law considers wiretapping to be very intrusive. Well, this is 2004, mind you. Therefore, it is closely regulated by federal and state law. A court will permit wiretapping only for a limited period. The authorities that listen to your telephone calls must make efforts to minimize the intrusion by limiting the number of intercepted calls to those involving the investigation. An example of this would be tapping a bookie's telephone only during the hours when it is likely that bets will be placed. After the wiretap period has ended, the authorities must inventory the calls and reveal to the court the content of the conversations they intercepted. Less intrusive forms of electronic surveillance are the PIN register and the trap and trace. A PIN register device records every number dialed from your telephone. A trap and trace records every number dialed from an outside line to your telephone. These devices do not enable anyone to listen to your conversations, as they simply list telephone numbers. You should assume that any conversation from a jail or visitor's phone is being tapped. Obviously. Let's say that again. You should assume that any conversation from a jail or visitor's phone is being tapped, because it is. The recording system is automatic. It's not like they have to have somebody in a huge data center, watching for inmates to make calls. All the recordings are automatic. It's done by a machine. And you have no idea how many hours of my 20s and early 30s were spent listening to these bloody jail calls, because people they hear the disclaimer, this call is being recorded by company X. They hear it and they think it's, a bluff or something? Like, no, nobody's really listening to this call. Man, I've spent so much of my life listening to those stupid calls. Don't talk on the phone. If you're in a jail, do not talk on the phone, especially if you're my client. I will hate you. Don't do it. Do not talk on the phone from the jail. Don't talk about the facts of your case at the jail. Like, you are being recorded, and the prosecutor will have it. They have people dedicated to listening to those calls, man. Use some common sense, please. Don't talk about your case on the jail phone. They are listening to you, and they will come into court. It will come into court. If you have a no-contact order, my God. I had one case. Dude has a no-contact order, goes to jail, immediately contacts the person, immediately, on the phone, plain as day, contacting the alleged victim in the case. Unbelievable. It happens all the time, and they tell you it's being recorded. For the love of all that is holy. One of my biggest pet peeves. Do not discuss any aspect of your case with anyone in jail except your lawyer. Or anyone anywhere except your lawyer. Don't talk about it at all, anywhere. Not in interviews, not with your friends, not with your parents, not with your kids. No one. Do not talk about your case except with your lawyer, right? Famous example of that is, as Love is Everything mentioned earlier, the Manson case. Girl started just talking to her jailmate, or her cellmate. Cellmate went straight to the prosecution and said, this psycho just told me about all these crimes. I want a deal. That happens a lot. Inmates will rat each other out like that. Do not talk to your cellmates about whatever crime you're charged with. It is also technologically possible for the police to tap a cellular telephone. There's a quaint 2004 textbook for those of you just joining us. So this is a little outdated. Obviously, police tap everything, and they don't have to because Verizon will give it to them for free without them even asking for it, right? Facebook, Instagram, maybe not Twitter anymore, but if you haven't read the Twitter files, you need to go read it. Like, they will just hand over everything on you. They don't need a subpoena. They don't need a warrant. Nothing. They'll gladly cooperate with authorities to turn over whatever they want and lick their boots in the process. So this is a quaint textbook from 2004 about your legal rights against surveillance. Question, has the law regarding telephone taps and other surveillance changed since the terrorist attacks of September 11th, 2001? Boy, I don't even want to read this section. The next section is, has the constitutionality of the Patriot Act been challenged? Boy, I remember those days. Back in 2004, everybody talking about surveillance and the Patriot Act, and they thought, like, well, if we, raise enough stink about this and challenge the constitutionality, it'll change things. At this point, all these years later, I tell my kids, I'm like, you were born into a different country than the one I was born into. There's America before 9/11 and America after 9/11. And they're night and day. So a lot of this, I'm not even reading these sections in this book because it's just depressing. Thinking about the country we used to have before 9/11 and the Patriot Act and all that stuff. Question, may the police search me without a warrant? A, that depends. That's a lawyer joke. Anyone who has been to law school in this audience will know the correct answer is always, it depends. Answer, that depends on whether you are under arrest. If the police have lawfully arrested you, they are permitted to search you. It's a search incident to arrest. They are also allowed to search the area under your immediate control, also known as your wingspan or where you can reach. This may include, for example, the glove box of your car. So, if you're sitting there in your car, you get pulled over, police arrest you, they can search you, your person, when they pull you out of the car, and they can search your seat, and they can search anything you might have reached to, right, while you were sitting there, like to hide drugs or hide a weapon. Like, that's your wingspan. Where are we at? If you are not under arrest, the police generally are not permitted to search you. There are a number of important exceptions to this rule. The police may search you if you consent, but doing so limits the range of your defense in later proceedings. Your consent, for example, will make it difficult to challenge the legality of the search at a pretrial suppression hearing. Many people feel they should consent in order to show the police they have nothing to hide. But what you consider insignificant, such as a piece of paper with a telephone number, may be incriminating if it links you to a crime. Don't consent to searches. I don't care who you are. I don't care what situation you are in. I don't care how benign it is. I don't care how you think it's going to prove your innocence. Do not consent to a search. This program is for educational purposes only and entertainment purposes at best. Do not consider this legal advice, but don't consent to a search. You say no. Say no. Just say no. Don't do it, man. Do not consent to a search. You know how many people I've had say to me, Mr. Invictus, do you think if I had cocaine on me, I would be stupid enough to let the police search me? Come on. Yes, I do think you are that stupid because I've seen it 100 times. People think, well, I'm going to consent to the search. And when they find this cocaine on me, I'll say, do you think I'd be stupid enough to let you search me if I had cocaine? Obviously, that was planted. By you, police officer. Happens all the time. People are that stupid, yes. Or they forgot that there was cocaine in their pocket. Whatever the case. Happens all the time. Just don't do it. Don't do it. Because if you do have cocaine in your pocket, I'm not telling you how to break the law or get away with it, but if you do have cocaine in your pocket and you give them consent to search, you've just given yourself up. You might as well start squeaking like a parrot, saying, yep, I had that cocaine. I bought it from my cousin Jim. And you know what? I'm going to take a plea. I totally did this. Just take me to prison right now. You might as well. Because you have given consent. You've given up your entire case. If you don't consent and they search you illegally, like they don't have a warrant, they are not searching you incident to arrest because they didn't have probable cause to arrest you, or it's proved that they were harassing you and had no reason to arrest you at all and searched you, again, illegally, as part of the course of that illegal arrest, you can have that suppressed. That evidence gets thrown out, and then there is no case against you. Again, I'm not telling you how to get away with having cocaine on you. I'm using that as an illustration. Do not consent. One of the things the ABA points out here is you might think that it's benign or that it is insignificant, it has nothing, but you have a piece of paper in your pocket and it has a phone number on it, which is their example here. As a telephone number, you don't think this is important at all. Well, to a detective who has tunnel vision, you have the phone number for, I don't know, Anthony's restaurant in downtown Phoenix, right? Why do you have that in your pocket? Well, I don't know. I talked to my cousin Bob, and he said we should go there, and he gave me this number. I was going to make a reservation. Well, that's in your head. But this idiot detective with tunnel vision is thinking, the deceased person ate at Anthony's 2 weeks ago. There's clearly a connection here. He ate at Anthony's 2 weeks ago. Now he's dead. This person has the phone number for Anthony's in his pocket. Coincidence? I'm a detective. I don't believe in coincidence. He did it. So just don't consent. Do not consent to a search. For God's sake. All those memes, like those lawyer memes about clients ignoring your legal advice, I don't know how many times I've straight up told people, do not do this, and they do it anyway. So I know, 90% of you are probably listening to me for real right now, but 10% of you, I'm upset with you. This past me right now is upset with you in the future for not listening to what I'm telling you right now. Do not consent, and do not talk to people on the jail phone. It's being recorded. And don't lie to your lawyer. Question, does the law permit the police to search my home or items in it? Answer, you have greater rights in your home than you do in your car. And we're going to have to stop there today. Sorry for the abrupt stop, but we're over time. And I do have a job to do. And we've got a lot of clients that got to get their work done. So we are in the middle of a work day. This is part of my work. Legal marketing, we call it. So content marketing, technically. So anyway, we might continue this. There's a significant portion left of this chapter, lawyers and criminal law. There's a lot of this. Let's just do a part 2 of this next week. How about that? If y'all have any questions, bring them with you to class next week. You can put them in the chat. We'll talk about it. Let me see if there's anything in the chat today that I missed. Government prosecuted Sean Walker of the NA for an alleged bar fight where there was no victim to be found. about. He was convicted and served about 7 years, if I remember. I don't know about that case, but that does not surprise me at all, because he's with a group that has no constitutional rights. Guilty by association, right? Which we've talked about before. What are your thoughts, says Profanity Lord, what are your thoughts on the recent tyrannical police departments in Florida colluding with the ADL to prevent people from distributing anti-Semitic flyers? I can't comment on that for reasons that I can't say. I'm going to leave it at that for right now. Where can the Guerrilla episode, the Guerrilla Radio Waco episode be found? That's a good question, the Smoking Medic. I don't know. I know that someone out there, some enterprising soul, downloaded all of the Guerrilla Radio episodes, and they're somewhere out there on underground websites, but I don't know. So if you find it, please do let me know. Otherwise, we will see all of y'all next week. We're going to do a part 2 of the basics of criminal law. Until then, stay out of trouble. Do not talk on the jail phone if you get arrested. Don't lie to your lawyer, and do not consent to a search. Until next week, everyone, stay safe.